You better think twice before putting your child's name on your deed. Hi, I'm attorney Paul Bernstein of the Bernstein Law Group. Why do I say you better think twice before putting your child's name on the deed of your house? Well, you're probably thinking, oh, I'll put their name on the deed, so if I pass away, it'll just go to them. They'll own it. No court involvement, no lawyers. Simple and easy. That's true if everything goes correct. Let me tell you a particular story where things didn't go quite as planned. A particular woman put her children's name on her deed. Sounds like a good idea. So when she passed away, it would go to them. No courts, very simple. No lawyers, easy. Well, what she didn't anticipate was the middle son having a particular illness where it resulted in him being completely incapacitated. A conservatorship had to be undertaken to grant someone else the authority to sign on his behalf. Mother wanted to sell the property, and everyone agreed to sell it, but the 25% ownership interest of that middle child that was incapacitated, which was now controlled by the conservatorship, wasn't going to be returned to the mother. It was going to stay for the benefit of the incapacitated son. The court required that. That very sad, unexpected. If that wasn't bad enough, mom, who was really dependent on the proceeds from the sale of the house, ended up finding out that the other sons, all three sons in fact, were going to get less than she did for her percentage. Why are they getting less? Because it was her primary residence, she got to exclude $250,000 of capital gains taxes. That's a great benefit in the tax code for your primary residence. But because the other three children whose names were on the deed, it wasn't their primary residence, they didn't get that exclusion. They had to pay capital gains on their 3/4 that they received from the sale of the property. So one, she didn't get the proceeds from the middle child who was incapacitated. Two, she got less from the other two because they had to pay 20% capital gains tax for those funds. So simple and easy ended up costing this particular person an awful lot of money. Another case was parents put a son on their deed. Same reason. Son was a successful business owner until he wasn't. Son's business struggled, and then finally he declared bankruptcy. And when that happened, the bankruptcy court trustee stepped in and forced the sale of everything he owned, including his percentage of the parents' house. His name was on the deed. He co-owned it. So the trustee in bankruptcy was going to put it out to market to sell. That would have meant that the parents would be co-owning their house with a stranger. This upset them so much they had to buy back their own house from the bankruptcy court trustee. Other cases are children going through a divorce. They co-own the house. Now the parent's home is part of the child's divorce proceedings, or a child gets sued, co-owns the house. Now the parents could lose the house to the child's lawsuit creditors. When you put your child's name on your home to simply avoid probate in what you believe to be a simple and cost-effective way, you have now placed your world into the problems of your children. I strongly advise clients not to add their children's names onto what they own and invite the child's world to come and attack their home. Never intentional. Things might look perfect when this is done, but life happens and things can go awry. There's much better solutions. So once again, be careful of the perils of adding someone else's name on your property. I hope you found this video informative. If you have any questions or just not sure what to do, feel free to reach out. Thank you.